And now let's head on over to the state of Maine, where a very interesting story is unfolding. Basically, last week, the U.S. Supreme Court stepped in and they reinstated the voting rights and the speaking rights of a state representative. Basically, up until that moment, this particular state lawmaker, she was not able to vote or speak in the House, despite the fact that she was elected for that seat. She was sent there by her local constituents, but she was not able to do anything despite having been elected. And the reason for why exactly that is fascinating to say the least. And so let's go through it together right after you take a super quick moment to smash those like and subscribe buttons so that this story can reach ever more people via the YouTube algorithm. So let's begin. Right now, the state legislature of Maine is currently controlled by Democrats, although it is really worth mentioning that Democrats only have a slight majority in the state House. Just looking at the one-sided presidential election results in the state of Maine, you might assume that their state legislature is similar to Oregon or Washington state, which is really one-sided, almost a supermajority by Democrats. But actually, it's not. In the state of Maine, out of the 151 available seats in the state House, 76 are controlled by Democrats, while 73 are controlled by Republicans. And then the remaining 2 seats are held by independents. Meaning, as a practical matter, that the Democrats hold a narrow majority in the state legislature. And you'll see why that's relevant in a moment. Now, back in January, when President Trump assumed office, one of his first executive actions was an order that related to transgender athletes in sports. Specifically, he signed an executive order, you can see it up on your screen right here, titled Keeping Men Out of Women's Sports. The practical effect of this executive order was that schools across the country that continued to allow transgender athletes to compete against biological girls, they ran the risk of having their federal funding cut. They would no longer get federal dollars sent to them. And shortly after this executive order was signed, you had a very tense exchange between President Trump and Ms. Janet Mills, the Democrat governor of the state of Maine. Take a look.
The NCAA has complied immediately, by the way. That's good. But I understand Maine. Is Maine here, the governor of Maine?
Well, here.
Are you not going to comply with it?
I'm complying with state and federal laws.
We are the federal law. Well, you better do it. You better do it because you're not going to get any federal funding at all if you don't. And by the way, your population, even though it's somewhat liberal, although I did very well there, your population doesn't want men playing in women's sports. So you better comply because otherwise you're not getting any federal funding.
See you in court.
Every state, good. I'll see you in court. I look forward to that.
And so all this was the backdrop for what happened with Miss Laurel Libby. Miss Laura Libby is a Republican representative in the Maine state legislature. She specifically represents District Number 90, located roughly an hour's drive north of Portland. And back in February of this year, amidst this whole debate surrounding trans athletes, Laurel posted the following on Facebook, highlighting a certain transgender student athlete who had won a girls' track and field competition. Here's what she wrote, quote, "We've learned that just 1 year ago, John was competing in boys pole vault. That's when he had his 5th place finish. So all of this transpired in the last year with the full blessing of the Maine Principals Association. 2 years ago, John tied for 5th place in the boys pole vault. Tonight, Katie won 1st place in the girls' Maine State Class B championship." And then right below that message, she posted 2 photos of that same individual 1 or 2 years apart. And please do note, we here at the Epoch Times, we're the ones who blurred the faces of all the students in those photos. The original photos, the ones that were actually posted by Miss Laura Libby, she very specifically did not blur all the students' faces, including the face of the transgender student, which is exactly the point which caused, you can say, quite a bit of controversy within the Democrat-controlled Maine state legislature. Not only because, well, the topic of transgender athletes was a hot-button issue at that time, as it is now, but also because the athlete in question, the one that Laurel highlighted in that particular post, he was a minor. He was competing at the high school level, meaning he was probably somewhere in the range of 15, 16, or 17 years old when those 2 photos were taken and when the post was made. The criticism against Laurel was that by posting the name and photo of that particular student, she was putting him in danger, both psychologically and perhaps even physically. At the time, you had many news stories running locally in the state, such as this piece here on a local ABC affiliate over in Maine.
What about her argument that the student is participating in a public event, it's at a high level, state level? Does that change your opinion at all, or do you still think it was?
No, I accept the fact there are many people who know this student, people in that school, in that district, but that's one thing. But putting it out on social media means the whole world can weigh in on this, and that's generally not a good thing. Ethan?
Yeah, just really, I used the word disgusting earlier about what Donald Trump was doing. This is that times 12. Just really inappropriate to use kids. We're always very careful when we're in elected office not to cross certain lines. She can have whatever position she wants to have. Maine law is clear. What the Maine Principals Association has done is clear.
Now, it was at this time that Laurel was asked by the Maine legislature to issue a public apology. She refused, saying that she will not be silenced, but then she was actually silenced. In February of this year, shortly after she made this post, the Maine state legislature voted to officially censure her. The vote was 75 to 70, falling almost completely along party lines. The censure resolution was passed, you can see it up on your screen, and it accused Laurel of unapologetically putting this child in danger and therefore violating the legislature's code of ethics. And it also said that she, quote, conducted herself in a manner incompatible with her duty and responsibilities as a member of this House and the public trust and high standards incumbent in that office. Then, right after the vote for this resolution went through, you had the Speaker of the Maine House. He spoke up in the chamber and he offered to give Miss Laurel Libby an opportunity. He offered to give her time to draft an apology and present it to the full House. Laurel immediately refused this offer, and she went outside and told the reporters who were there waiting the following.
I will not apologize for speaking the truth. And the truth is, there are biological males who are taking the place of biological females in Maine sports, taking their podiums, taking that excitement that they've been working for so many years. I think about those two girls who should have been first place in the state championship pole vault and the disappointment that they faced when a biological male took the podium instead of them. I will not apologize for speaking up on behalf of Maine girls.
In that same interview, Laurel also pointed to several national polls, you can see them up on screen, showing that the vast majority of Americans don't believe that transgender athletes should be allowed to compete in girls' sports. All right, just to pause here for a super quick moment, I'd like to introduce our sponsor and my own personal gold dealer, American Hartford Gold. Now, as soon as the latest round of tariffs hit, almost immediately, the stock market hit some serious waves, we could say. It became super turbulent, very volatile, and of course, these conditions don't just affect Wall Street, they affect all of us with our investments and our retirement accounts. That's why I want to introduce a company that I trust and I use myself to help secure my own savings, American Hartford Gold. They specialize in helping Americans move their assets into something tangible, something you can actually hold, physical gold and physical silver. Two precious metals that help me sleep better at night, knowing that I have a hedge against all those brilliant decisions being made over in Washington. Now, they have an A+ rating with the Better Business Bureau. They have thousands of 5-star reviews, and they make the whole buying process super simple. Your metals can be shipped directly to your doorstep, or you can transfer your current retirement account to a tax-advantaged gold IRA. And the best part is that right now, American Hartford Gold is offering an exclusive buy one, get one deal for my viewers. When you call them and mention my name, Roman, for every 1 ounce of gold that you purchase, you can get 1 ounce of free silver. And so take advantage of this special offer. Either call 866-242-2352 or simply text Roman to 65532. That's again, 866-242-2352 or text Roman to 65532. I'll also throw their information. It'll be down in the description box below. Now, this is where things, you could say, got interesting. The censure resolution that was passed against her, it mentioned two specific laws. Here's what it said, quote, pursuant to Article 4, Part 3rd, Section 4 of the Constitution of Maine, which states that each House may punish its members for disorderly behavior, and pursuant to Section 561, Subsection 1 of Mason's Manual of Legislative Procedure, which states that a legislative body has the right to regulate the conduct of its members and may discipline a member as it deems appropriate, including reprimand, censure, or expulsion, the House is the judge of its own membership. What this meant in practice is that because Laurel refused to apologize for her post, she was no longer able to debate on the House floor or cast any votes. She was still a member of the state legislature. She still represented thousands of constituents. It's only that she could no longer speak or vote. Now, after finding herself in the situation, Laurel filed a lawsuit against the Speaker of the House, arguing that this action disenfranchised her constituents. Here's specifically what that lawsuit stated. Quote, "The verbal censure, unwise as it may be, is not what we challenge here. It's what happened next. The Speaker declared Libby was barred from speaking or voting until she recants her view. This means her thousands of constituents in Maine House District 90 are now without a voice or vote for every bill coming to the House floor for the rest of her elected term, which runs through 2026. The ongoing and indefinite denial of Libby's voting rights is unprecedented and goes against what the U.S. House of Representatives found long ago, that the Constitution forbids that chamber from preventing one of its members from voting at the federal level. The member's vote is not her own. It belongs to her district, and depriving an entire district of representation is no more constitutional than excluding that district from a redistricting plan in the first place. The same rules apply in Maine." And as such, she was urging the U.S. Supreme Court to step in and issue a preliminary injunction which will allow her to speak and to cast votes while the case actually plays itself out in court. On the flip side, however, you had the Democrat Speaker of the House arguing that the U.S. Supreme Court should not take up the case, writing in his brief that, quote, "On February 17th, Libby targeted a high school student who had competed in an event because that student is transgender and identified that student by name. The post, written on her official Facebook account, quickly went viral. I saw the post and was immediately concerned about the student's safety and welfare and sent a letter to Libby urging her to delete the post. Libby declined. The Maine House passed a resolution with a vote of 75 to 70 requiring Libby to accept full responsibility for the incident and publicly apologize to the House and to the people and the state of Maine. Like other censures of Maine House members, the censure resolution required Representative Libby to apologize for her conduct, not recant her views. Libby declined to apologize, and therefore it was determined that Libby had violated House rules and she could not participate in floor debates and floor votes until she apologized. And so these were the two competing briefs that were sent over to the U.S. Supreme Court. And it took a few months, but just last week, the U.S. Supreme Court did decide to finally get involved in this case in support of Laurel. Specifically, in an unsigned order that you can see up on your screen, the U.S. Supreme Court went ahead and restored Laura Libby's speaking and voting privileges. Now, notably, this order from the U.S. Supreme Court, it was not only unsigned, but also it did not provide any reasons for the decision. It only restored her privileges while the case itself plays out in the lower courts, meaning that while the case is still playing itself out, Laura Libby can continue to vote and speak on the House floor, which she has access to until at least 2026. That's when her current term is up, although she has already announced plans to run for re-election. We'll see how that goes. And there is something else that I want to mention in regards to this particular case. In doing research for this story, my initial assumption was that this was a blatant violation of the First Amendment. I mean, after all, how could you silence an American elected representative unless they apologize for something they said or did earlier? It seems on the face of it to be in violation of the First Amendment. However, let me read to you an analysis of this particular case that was posted on the Federalist Society website. It's a bit long, but it does add quite a bit of solid nuance to this particular situation, so I'll read it to you. Quote, "The case involves important questions about free speech, election law, and the court's use of its emergency docket. A few things are clear. Whether appropriate or not, Representative Libby's post was protected speech, and her punishment was imposed because of the content of that speech. The U.S. Supreme Court's decision appeared to signal that the discipline was unconstitutional, although the court issued only a brief order and did not explain its reasoning. The main question, then, was whether her ability to serve in the legislature could be conditioned on compliance with speech restrictions that could not be applied to the general public. Had Representative Libby been expelled from the Maine House, even on the basis of her speech, she might not have a First Amendment claim. Under Article 1, Section 5, Clause 2 of the U.S. Constitution, each House of Congress may expel a member by a two-thirds vote, and under the political question doctrine, federal courts could not review the basis for Congress's determination to expel a member. It is hard to believe that states would be prohibited from expelling legislators for their speech if Congress is permitted to expel its own members on that basis. But a refusal to seat a member is different from an expulsion. Although Representative Libby was neither excluded nor expelled from the Maine legislature, her punishment is more like an exclusion in that it was effected on the basis of a majority vote rather than the two-thirds threshold required for expulsion. And so what they're essentially saying here, in my limited understanding, is that the U.S. Congress at the federal level is able to expel its own members if they so choose, such as a great example, George Santos. He was expelled in December of 2023. Congress had the power to do that, and they did that with a 2/3 vote. Expelling George Santos, it stripped him of all the privileges that came from being in Congress, which of course included being able to speak in the House floor, debate issues, as well as to vote. And so does what happened to Laura Libby in Maine fall under that general purview? Is her getting stripped of her voting and speaking privileges the same thing as George Santos getting kicked out of office? Is that something that the state house is able to do without question? Or are they not because it was done by a majority vote rather than a 2/3 vote? It's an interesting question that'll have to get answered by the courts. However, as this article from the Federalist Society does mention at the very end, well, just based on the U.S. Supreme Court's order, it seems that they are siding with Laurel. Quote, "For the majority on the U.S. Supreme Court, it was indisputably clear that stripping Representative Libby of her authority as a legislator because of her speech violated her rights and the rights of her constituents." But I'd love to know your thoughts on this particular matter. Do you think that what Laurel did was protected free speech? Or if it was protected free speech, do you think that her highlighting a specific student who was a minor and dragging him into the national spotlight was an appropriate thing for a lawmaker to do? And if it was inappropriate, do you think it was grounds enough for the state legislature to censor her for violating their code of ethics? I'd love to know your thoughts. Please leave them in the comments section below. I'll be reading through them tonight as well as into the latter part of the week. And then also, if you'd like to read any of the documents related to this whole story, I'll throw those links down into the description box below, which I will mention, as always, is that same description box right below those like and subscribe buttons, both of which, if you haven't already, I hope you smash so that this content can reach ever more people via the YouTube algorithm. And then until next time, I'm your host, Roman from the Epoch Times. Stay informed, and most importantly, stay free.